Welcome once again, certainly to our candidates and new audience members. I don't know if they're ready, but this is our third and last panel for the Court of Common Pleas. There are 3 seats open and a total of 6 candidates, and we have 5 of them tonight. Basic ground rules. We talk about respect and civility from the audience and the candidates. I'm sure that's not going to be a problem. No cheering or anything like that. Please turn off your cell phones if you just got here. From the candidates, we know we're going to get constructive engagements rather than pot shots. Please abide by our time limits. They are primarily 1 minute and 30 seconds, depending upon that part of the program. Each candidate is going to get 1 minute for the introductions and closings. There will be 3 questions. Each question will be posed to 2 candidates of opposing parties, who will get 1 minute each to respond. The rest of the panel will then get 30 seconds to respond to that same question, because it's not your primary question. And then we'll move on and ask another question where we go for a minute for each candidate. And if that sounds confusing, we'll work it out. Audience questions too are going to come from the floor, and we're going to get those in as best we can. So I think that's pretty much it. So opening is 1 minute, and why don't we start from your end?
Okay. All right. So good evening, everybody. I first want to say thank you to Steve and to Citizens Call and all of the community groups here in Cheltenham for hosting us tonight. For those of you who I haven't met personally, I'm Natasha Taylor Smith. I live right here in Cheltenham, right down Church Road with my husband. We have 3 children. They're 27, 15, and 12. I am a graduate of Temple University School of Law. I started my legal career off at the Defender Association of Philadelphia, trying serious felony cases for people who simply could not afford their own attorneys. And then I was in private practice. I did family law, personal injury, criminal law, those types of areas that most intimately affect our everyday lives. And now I get an opportunity to go to work every day and represent each of you as a member of the county solicitor staff, where I represent aging and adult, behavioral health and developmental disabilities, commerce, and housing. I'm done. The 15 seconds is up, so I'm done.
Good evening, everyone. My name is Stephen Heckman. I have a private practice, solo practitioner in Bluebell. I live in Upper Dublin with my wife, Patty. We've been married for 27 years. I graduated Penn State. I'm also a Temple Law graduate, 1981. So I have 34 years of experience, the most of anyone running. I'm the only one who served as both a district attorney and a public defender, and I was also lucky enough to be appointed the chief public defender of Montgomery County. So I've dealt with and represented a lot of individuals who are downtrodden and victims of society in some respects. And I would ask you to consider the fact that I also have been a family law practitioner, civil rights actions, and the like. And I'm prepared. I believe I can handle any area that I'm put into in the courtroom, and I can hit that without learning on the job. Thank you.
Good evening, everybody. I appreciate your attention tonight. I'm a resident of Dan Clifford, and I reside in Springfield Township, also your neighbor. I've served for 20 years as chair of the zoning board in Springfield, having been appointed and reappointed by both Republican and Democratic commissioners throughout those 20 years. I have served with dignity and respect to all the applicants that come before us. My son is a junior at Springfield High School. I'm hesitant to mention that given the score of Friday night's football game against Cheltenham, but please don't hold that against us. I like to talk about family court because I believe our family court is the most accessible division of our courthouse. Last year, 4,600 cases were filed alone just in family court. So it's important from my viewpoint to have lawyers who are willing to serve as judges in family court because it is so accessible to our residents. Most of our residents in our county will actually be more involved with family court than they are in criminal court, which is a good thing. But I think that looking at the questions that are coming up, hopefully we'll get some questions that also deal with what I believe to be a very important division of our courthouse. Thank you.
Good evening, everyone. I'm Risa Vetri-Ferdman, and I'm honored to serve as your district attorney. I've actually served in the district attorney's office for 23 years. I'm a local girl, and at the risk of losing votes, I should tell you I'm a graduate of Abington High School. And I'm a resident of Abington, but I actually started my career as a prosecutor at Cheltenham when I lived over here on Aspen Way with my husband when we got our first home. I decided to be a prosecutor because I wanted to stand up and speak out for people, to help them find justice. And I think if there is a defining trait of my tenure in the DA's office, it's protecting the most vulnerable, whether it was founding Mission Kids, a child advocacy center, or founding the Montgomery Child Advocacy Project to provide legal representation for kids, or creating our first elder justice task force, or partnering with our schools. My approach to our justice system has always been problem solving and helping those who need the most help. As a mom, I've been very proud to let my children know what justice is about. I'm told that time is up, I have to stop, so we'll talk more later. Thank you.
Thank you.
Good evening, everybody. First of all, I want to thank everybody. It is great to be here tonight. My name is Todd Eisenberg, and I actually grew up here in Cheltenham Township. I actually went to a senior prom in this building, and I think that's the last time I was in here. But really, I appreciate being here. I started out my legal career, like Natasha, at the Defender Association of Philadelphia. I spent 3 years there. After I left that office, I was on my own in the city of Philadelphia handling criminal cases. I learned how to do family cases and personal injury cases. Then I came back here to Elkins Park and worked at a firm on Old York Road. At the time it was Jaffe Friedman, then moved to Jenkintown as Friedman Schumann. And for the last 6 years I've handled all the civil litigation for Pico Energy. But the thing that is most important to me, it's always disconcerting when you see that notice. The thing most disconcerting, why I wanted to run, is to deal and protect the most vulnerable people in the system. As Risa talked about, I volunteer my time through the Montgomery County Child Advocacy Project, and it's really great to work with kids and take them into court. I have to stop, so thank you.
Thank you. We're going to move into our questions at this point, and we start out with number one, fittingly enough. And we're going to move same direction, so we'll start off with Ms. Taylor-Smith and Mr. Heckman. Question 1 minute, Trey. As you know, the criminal justice system has come under greater scrutiny of late, especially involving people of color and the poor, regarding setting bail. Are you concerned that pretrial detention can sometimes reflect factors other than risk to public safety? How would you make decisions on bail so as not to disadvantage those defendants who cannot afford to pay?
I would say that I'm definitely concerned about the disproportionate number of individuals, people of color, who come into contact with the criminal justice system and consequently are faced with bail issues. Judges for the Court of Common Pleas, for the most part, don't set initial bails. Those initial bails are set at the arraignment before they come to the Court of Common Pleas. But I think that making sure that you are aware of, not just what the crime is, but what the purpose of bail is, that the purpose of bail is to ensure that an individual will appear in court in addition to issues of public safety, and focusing on those issues as opposed to the individual in front of you, if there are issues that don't necessarily involve those two when you're setting bail. So when you're doing bail reduction motions, when you're doing motions to increase bail, you want to make sure that you are aware of implicit biases that might exist and that you eliminate those from your decisions.
Thank you. in being on both sides of this issue, both as a prosecutor and a defense attorney, the key issue, aside from the crime itself, if we're looking at something like a person with 2 or 3 armed robberies, then I think public safety outweighs other considerations. Yet if we're looking at an individual who should not be punished pre-trial because he hasn't been convicted of anything yet, I look at their family. Are they connected with their community? Are they likely to show up in court? Do they, have they ever missed a court appearance before? That's all the information I have before me. If they haven't missed an appearance, they've got good connections with family in the community, and also if they have a job, that's important as well. Then there's something for me to decide that to take a chance on that person. And I agree, we cannot base this on color, but we must protect the community and the individual's private liberty interests. Thank you.
Okay, now we go into the 30-second round, where the 3 of you have a chance for 30 seconds to respond to the same questions.
Just go
Okay.
on.
Starting with Cindy.
Sure. So I'm a family lawyer. I've been a family lawyer for 30 years, and I think there's probably a 0 chance that I would ever be assigned to criminal court because all the judges in the courthouse would most likely be very happy not to have to serve in family court. But let me say what I think your question really drives at, and that's discretion. I think judges should have discretion. The outlines for bail provide discretion to the judge, just like we have discretion in family court for alimony or for child support. The important thing is to be able to have judges have that discretion so that they can view each case on a case-by-case basis, and they're not looking to a guideline as a specific number for whatever crime they may be charged with. Thank you.
I think my colleagues have addressed what the bail rules say and the things judges need to consider. What I would share with you is simply as a matter of my practice as district attorney. I developed a partnership working with our public defender's office to address this very issue. Across our county, our district judges set bail, and we developed a protocol in the county where we could then review matters of bail just to make sure that bail was not inappropriately set for someone based upon these issues, based upon issues of race or of financial inability, and to make sure that our system was working in as fair a way as possible. That's what I did as district attorney, and the same considerations would be before me as a judge, because I know how to do this job.
Thank you. Really, it comes down to fairness and respect. As was already said, bail is set, 1, for public safety, and 2, if a person is a flight risk. And unless someone can show, the district attorney's office at the time can show that there are issues there that the person, i.e. has missed court appearances, has lived in 10 different places, has no connection to the community, or they are not a danger to the community based on their past record or whatever the crime is that they're charged with, that bail has to be set fairly. And really it comes down to fairness and respect and not discriminating against anybody. Thank you.
Thank you. We're going to go to question 3. And so we will move to Mr. Clifford and Ms. Freeman. Question 3. What is the difference between a judge's role in adult criminal court and a judge's role in juvenile court? How do you approach sentencing for children as opposed to adults?
I think one of the most important considerations, if I were to serve in juvenile court, is to be able to look at the infraction that juvenile may be charged with and try to come up with a remedy or a sentence that would make sense. Many of our juvenile offenders are involved in very minor type activity. It might be, stealing change from a car, smoking a small amount of marijuana, and perhaps there should be a better consideration as to what that remedy would be for them or their sentence. That's why these youth aid panels that serve the county, I think, are a great idea because they go before their peers and also other adults, and they come up with basically a remedy that serves the crime that they're being charged with. So I think the most important thing is for juvenile judges to take into consideration that obviously when a juvenile is appearing before them, they're not an adult, and there are different considerations in terms of how they may have arrived there. And also, in most cases, hopefully the juveniles are having their family and their parents there to support them. Thank you.
Thank you.
So the first thing I think we should address is that in the juvenile system, the focus of the system itself is rehabilitation. It's not punishment or the impact on the community as it might be in adult court. With our juveniles, we look to get them on the right track. So diversionary programs, like Mr. Clifford referenced, youth aid panels, I run them out of my office. They're a program of the district attorney's office for lower level offenders, first-time offenders, to impose a measure of justice and rehabilitation, but not to saddle them with a record that will follow them forever. Within the juvenile system itself, I founded a program called Back on Track, a partnership with Big Brothers, Big Sisters, and our Public Defender's Office, to work with kids who need mentors, who have made some bad decisions, mistakes, and to get them back on the right track. But when it comes to those offenders who are in court, who have not a sentence, but a disposition imposed by a judge, our primary focus needs to be how do we rehabilitate this young person to get them to a place where they can lead productive lives.
Thank you.
Thank you.
Now on to our 30 seconds, and we can, oops.
Do I answer?
30 seconds.
Okay.
30 seconds.
So I'm now in the 30 seconds of this question. In my years in the Defender Association of Philadelphia, I represented many children in the delinquency area when they were brought before there. And one of the important things that I learned representing children there was, as was talked about by Risa and Dan, is that really it's about rehabilitation, not just getting convictions. Also, there were a lot of times where a judge would look at the case and realize that the child really needed support more out of the dependency system than the delinquency system. Dependency meaning that they really need help because they're not going to school, etc., not to just get convictions. Thank you.
So, it's-
30 seconds. 30 seconds.
which one?
Mr.
I'm sorry. Yes, we all know it is clearly rehabilitation for the juvenile, but I must say our Supreme Court has found that standards are evolving. The Supreme Court has ruled unconstitutional that juveniles get the death penalty. Our Supreme Court has ruled it unconstitutional that juveniles serve a life sentence. Why? Because the juvenile brain is not fully formed at a young age, and they haven't been given a chance to go through society. I think that it's important to treat the juvenile much differently than the adult, and you have a chance to save and mold a life at that stage, whereas after that stage it may be impossible to do anything more than incarcerate.
I think that you want to dispense fair justice to both juveniles and to adults. With the focus for a child being on, turning that child into a more productive citizen, fixing those things that might be broke, looking at the dependency system, looking at whether or not that child is a victim of abuse, his or herself, whether or not that child has the appropriate support systems so that they can do well. Placement and moving a child away from its community, disconnecting them from the community that they may have victimized is one sure way to keep the child in the system. And so I feel that children should be treated differently than adults.
Thank you. Now we have question 2. And that's for Mr. Rice.
Do I get 2 minutes?
I'm sure. What is your view of special court programs such as drug court, the recently terminated DUI court, youth aid panels, and others? Are they costly fads, or do we need more of them for the system to better serve society? Or is it somewhere in between?
I think they're very good ideas. When I first started practicing law, doing criminal work, what I would see happen was the idea that people would get arrested and then they would get convicted. It didn't matter if they were for violent crimes, drug crimes, or like petty theft crimes. And I really give a big shout out, for lack of a better term, to the criminal justice system for coming around on this issue. Drug court, which I saw start happening in the early 2000s, is a great idea. And I think back in when a judge said to a lot of the defendants who were in the drug court, where they would get really rigorous treatment in lieu of going to jail. And the judge said to these people that, in some ways you might rather go to jail because drug court is going to be rigorous and you're really going to have to follow through to get this done. So those programs are great because what they do is they take people who have problems and need treatment, and instead of just going with mass incarceration, they get them treatment and they help them move forward. Youth aid panels are great as well because it helps find juveniles who have issues and doesn't get them burned with convictions.
Thank you. 30 seconds. I don't know which way we're supposed to go.
All right,
Ms. Taylor?
so if are we starting with me?
Yes.
Okay. I almost forgot the question for a second. I am a huge proponent of specialty courts. I think that you have to meet people where they are. And in order to better serve our communities, to better serve our residents, to keep our streets safer for longer periods of time, you put in the energy, the effort, and the expertise up front in the beginning so that you don't have to worry about rehabilitating somebody after they finished just a period of punishment. I think that they do a better job at making sure that individuals are not recidivists and that they don't repeat their crimes. So I'm a huge proponent of specialty courts.
I agree. I think they are very important. And Montgomery County has one of the finest drug court programs. We have a program for veterans, deal with a lot of post-traumatic stress. We also have mental health court, which deals with people who really don't belong in the jail but deserve treatment. We had a DUI court, which unfortunately I believe is more punitive than rehabilitative. There should be people who have serious alcohol problems belong in inpatient programs and not in jail where more serious criminals should be locked up. So the more programs we have, the better, since it helps society, it puts the right people in jail, and keeps the right people out of jail.
Thank you.
More than likely, everyone up here is going to say that they agree that these are good ideas. And I think that the basic reason why they're good ideas is because the judges that are assigned to those special courts have special training, special background, and expertise on dealing with those issues. So the people that are appearing before the judges are going to know that the person who's sitting there has that background and expertise when they're actually handling the case. One of the things we've been advocating for in the family court division is to have a protection from abuse division court, because there were 1,400 protection from abuse cases filed in 2014 alone. And we would like to have the same opportunity to have judges who are specially trained and have expertise on abuse issues when the litigants appear before them.
So as district attorney, and in my time as first assistant district attorney, I have been a huge supporter of specialty courts. I helped Judge O'Neill in the very early days of drug court, our behavioral health court, our veterans court, and then we worked on DUI court. So certainly I supported these programs. What I would share with you right now, one of the biggest problems we have in the justice system is knowing how to deal with our mentally ill. And while we do have behavioral health court, one of the things that we need to look for in the future is finding better ways to deal with those who suffer from mental illness. And that's going to be something that as we look to the future, we need to marshal our resources to be able to solve that problem.
Thank you. I have a question from the audience. How do you assess dangerousness? And I think it's probably in the context of bail, and perhaps other issues as well, when you're evaluating the impact on the community. And I would add, do issues like class and otherness get in the way? And
Are we
you
back?
take volunteers.
I feel like that's what I do right now, so maybe I'll start.
It's like the criminal laws debate.
Whatever she says, right?
Maybe.
So
Where do you want us to start?
I was going to say, so I'll start because we'll be back. That way everybody will feel fair, right? We'll be back where we started.
Yeah.
And everybody will get 1 minute.
Yeah, you get one minute.
Okay, so I think, you ready? So I think one way that you can assess dangerousness is that there are, best practices and evidence-based practices that you can use to kind of empirically decide on dangerousness. You want to look at the background of the individual. You want to look at the nature of the crime that was committed. You want to look at the victim, his or herself, to kind of, use the totality of the circumstances to determine dangerousness when you're talking about something like setting bail, or even later on down the line when you're talking about something like sentencing, because you want to make sure that when you're fashioning a sentence, that you're fashioning it such that you are taking into consideration the individual who's before you and the protection of the community as a whole.
The future dangerousness does come up in the bail concept, and I agree it does also come up in the sentencing concept. You can look at a prior record of someone we call a rap sheet. If they have priors for retail theft, or unauthorized use of a car, that's one thing. If they have prior aggravated assaults, attempted murders, and serious assaultive crimes, that's another thing. And then we also want to find out, does this person, or should this person have a mental health evaluation? As a judge, I would not be hesitant to ask for an evaluation from Building 50 over the state hospital, so I don't release someone into the community who may not be able to control his or herself. Are they taking their medication? Are they doing what they need to do to be safe? Is there a family to care for them? A husband, a wife, a family, or a support group? That is critical and to the issue of future dangerousness. So I would consider that very heavily.
On the issue of dangerousness, I think the most important decision a judge has to make is assessing whether or not the person who's committed or alleged to have committed the crime is going to be a danger either to the community or to the victim. That's one of the things we deal with most frequently in family court when it comes to abuse matters, is the person who's alleged to commit abuse against another party, are they going to be a danger to the other party? And I think the victim's safety is of utmost concern and should be to any judge. And I guess, I think it comes down to discretion. You want to be able to have the judges have enough discretion to assess each case as it comes before them and make those decisions, and not have something that you open a book and you say it's a guideline across the board and they're required to do it. I think, again, discretion is very important so the judge can assess that on a case-to-case basis.
So another way to refer to dangerousness is risk. It's risk assessment. What is the risk that this person is going to do harm to another? What is the risk that this person is going to do harm in the community? And that is perhaps one of the most challenging questions that a judge has to face, whether in the context of setting bail or of sentencing or any other decision that a judge has to make. And I think we are fooling ourselves if we suggest that there is a matrix or a list. There are many factors to consider. But ultimately, what that assessment comes down to is a judge's determination, looking at all the factors and all of the things in front of him or her that lead you to think that this person could in fact hurt another person. There are studies done, and there are work with the University of Pennsylvania doing risk assessments. But no matter what those risk assessments tell you, it's really going to be a very human decision, looking at all of the facts and circumstances and trying to decide whether or not you can take on the risk that that person might hurt another.
Thank you. Really, even after people become elected judges, you don't stop using common sense and reasonableness. And really, to assess dangerousness, a judge has to use common sense. Look at what the person is charged with. If they're charged with a buying of narcotics, or are they charged with armed robbery? On top of that, look at their prior crimes. Do they have 10 prior drug convictions for buying, or do they have burglaries, robberies, attempted murders? That person who has done the attempted murders, the robberies, etc., is a very dangerous person, and bail probably would need to be set higher. As compared to using common sense, if a person is really an addict, then common sense would dictate you don't need to set a high bail, even though they have a prior record score and a prior conviction. So really, it comes down to a judge that once they get on the bench, they still have to use the thing that we hope to use every day, common sense.
Thank you. We're going to do one more before we close. Okay, we're going to go to close. Okay, so closing is 1 minute segments for each of you. And we will begin, who wants to volunteer?
Why don't we go this way?
Yeah.
All right. Well, thank you. Thank you, everybody, for coming out. Thank you for allowing us to address this, and thank you for giving us such interesting, thought-provoking questions. Really, the one thing I want to leave everybody with is the importance of judicial elections. I know the county commissioners were up here and your local officials were up here as well. But really, when you look at it, judges can affect everyday life more than I think just about any other elected office. Judges can, through a stroke of a pen, take your kids, they can take your house, they can take your liberty. And that's why judicial elections are important. I would ask that you do research, look up all the candidates, look at our backgrounds, see what we've done. I have experience in criminal law, I have experience in family law, I have experience in land use and zoning, which are other issues that come before. I have extensive civil experience. So therefore, I'm just asking for your support on November 3rd. Thank you for your time tonight.
For over 2 decades, the question I get most often about elected officials is, tell me about the judge. I'm going to court tomorrow, tell me about the judge. And that's too late. These are elections that don't generate a great deal of attention. And I am so delighted to see so many of you out here, and I'm delighted that Citizens Call and other organizations schedule this. Because judges have more impact on our lives than any other elected officials. They affect our freedom, our finances, our family, all of the most important decisions that we can make and most important impacts of our lives. And I believe we need to select judges who we know and trust can uphold those standards and do things fairly. I encourage you to become educated, not just listening to us tonight, but to find out as much as you can. And I would be most grateful for your support on November 3rd in this run for judge. Thank you.
I'd also like to join my colleagues in thanking everybody for staying as late as you stayed tonight to listen to us for the last program, I think. And as I started to say during my opening statement, I do like to talk about family court because for the most part, everybody in our county is touched by family court in some way, and it may not be them personally. It could be from someone they know or someone they love. And for those of us who sit in the front of the room, we know as lawyers that all the new judges are assigned to family court, regardless of whether you have any experience in family court or not. In some ways, I'm disappointed by some of the questions because there were no questions about our family court system. And if you've had any experience in it, you know that it doesn't just take a year or 2 to get your case through our system. It can take many, many years, sometimes 3 to 4 to 5 years. And during that time period, the people that are suffering the most are the small children because their lives are held basically placed on hold while their parents litigate year after year. So I've advocated for a number of procedures to have our cases move more efficiently through the system. Hopefully you'll look at my website to look into some of the things I've proposed to improve our family court system. Thank you.
Thank you, Cheltenham. This is a great experience. If only the other 61 municipalities took it as seriously as you do, I think we'd love to travel, all 6 of us, to every other municipality in the county. I think it's important that we get to know the judges. It's hard. I always tell the lawyers, please educate your friends on the judges, and because they'll probably be asking you questions. But I feel that the 2 most important, and I'll follow up on Mr. Clifford's statement, 2 most important decisions I can make is whether how I decide child custody and how I sentence a criminal defendant. Do I give that person another chance for rehabilitation, or is he proved by his prior record that he deserves to be incarcerated for the safety of society? A New York judge recently let go of a man who ended up killing a cop. I never want to be in that position. We're not perfect, but I think my experience both as a DA and as a chief public defender puts me in the best possible place to make that decision. Thank you.
So that leaves me. Thank you again, Steve, and Citizens Call, and all of the other township groups who came out tonight to support this forum. Thank you for giving us an opportunity to talk to you, to tell you a little bit more about ourselves and about our candidacy. I'm going to say 3 things that I think that a judge should have. I think that judges should have real-life experiences that helps them understand the human condition, because it's very important that you show empathy, when individuals walk into your courtroom, regardless if you're talking about a criminal case, a family law case, or a civil case. I think that it's important that judges have a wide breadth of legal knowledge, and we all have that. We've all handled a variety of cases. I've handled criminal cases, personal injury cases, landlord-tenant cases, civil cases. And so I would be ready on day one to work wherever they put me. And finally, I think that temperament is very important. It's difficult enough to walk into a courtroom to talk about the most intimate and personal things that have ever happened to you in your life. If you get a judge who doesn't have patience, or who doesn't have time for you, or who's the smartest person in the room and wants everybody else to know. So on November 3rd, I ask that you consider my candidacy for the Court of Common Pleas. I will make you proud. Thank you.
Thank you. Our team is delighted that you all came and participated. Similarly, we're really delighted that you all came out. And without you, and for these candidates, doesn't be easy. So thanks so much for coming and participating and taking this stuff seriously.
Thank you.
Thank you.